we don't forget, everybody, if you want to pose questions, please put them in, use the Q&A function. I see we have had a question up there from Kate Jennings, who's been asking about the situation in Scotland and Scotland's ambition for independence and to rejoin the EU, and this keeping pace power. I see David's already responded to that in the chat, and I suspect that is an issue that we're going to cover as we move into the panel discussion. So hopefully, if we move on into the panel discussion, those sorts of issues about divergence between the four countries in the EU will start to become apparent too. So as I say, the panel discussion is going to look at where there are opportunities and threats of regulatory divergence, both for the UK as a whole, as well as for the four nations of the UK. So I just want to introduce our four excellent panelists, all of whom are engaged in different aspects of the divergence debate. First of all, we have Professor Colin Reid. He's Professor of Environmental Law at the University of Dundee and an associate with Brexit and the Environment, which is a network of academics who are analysing how Brexit is affecting the environment. We have Jill Rutter, who's already been mentioned this morning and been posting in the chat on the Divergence tracker that they're looking at UK and a changing Europe. Then we have Dr. Jane Clark from RSPB in Northern Ireland, and Peter Foster, who is public policy editor at the Financial Times. So welcome to all of you, and thank you for joining us this morning. If I can kick off with a question for each of you in turn. So we're in the early days of the UK's exit from the European Union. But can I ask you first to give us your perspectives on what you consider to be the most significant opportunities and threats that divergence poses for the environment in the UK from your perspective? And if I can start with Colin, perhaps, that'd be great. Thank you.
Yeah, good morning and good morning to everyone. I think really most of my concerns have in a sense already been addressed, in that the opportunity is, of course, there to tackle environmental issues in a proportionate way, to concentrate on the locally important issues. For example, a lot of the early discussions on the circular economy was talking about how environmentally beneficial proposals could be constrained by the EU's definition of waste, which was something that was just never going to change and was going to get stuck in the way. But I think the real threat are the things that's been talked about. The devolution settlement wasn't designed for this situation. There isn't the capacity for the devolved administrations, especially, to go alone on everything they're being asked to do. There is the mess as things get out of step, even when there is shared policy objectives. And the landscape is just so complicated, with the Internal Market Act getting in the way of effective governance, effective regulation of various things, the Northern Ireland Protocol, the Trade and Cooperation Agreement, trade agreements, and a lot of the post-Brexit legislation on agriculture, trade, now the Levelling Up Bill and so on, mucks around with the devolved reserved boundary. There are all sorts of ways in which the neatness of having the devolved administrations looking after their own thing is being eroded by these ad hoc changes. So I think the depressing future is one of mess. Whether you're deliberately trying to achieve something, the messiness is just going to make life harder for everyone.
Thanks, Colin. Well, let's see what are your perspectives on this? Do you concur with Colin that the future is mess?
I think it is going to be more difficult in the sense that the devolution settlement was designed within the framework of EU membership setting boundaries, and devolution in areas such as agriculture and the environment happened within that constraining framework. And now we've got these sort of substitutes for it in the form of the common frameworks approach that Theresa May's government was relatively keen on, where you'd negotiate sort of areas and legislate in relatively few of them. and now the Internal Market Act, which you could regard as a bit of a sort of blunderbuss cutting across that the Johnson government introduced. I think if you look at the big opportunity area, I do think that the agricultural reforms in England are potentially extremely bold and ambitious. You probably wouldn't have chosen to introduce them, though, against the backdrop of a food and energy crisis. I think they weren't really designed for that. They were designed for more normal times. But I do think if they can hold through the ambition, that it'd be really interesting to see whether something that I think a lot of people would agree was one of the environmental problems of the EU, namely the CAP, could be improved. I think that'll be really interesting and see whether the UK, certainly the English government for England, which the UK government's really confusing, can actually do something massively different. I think the bit that wasn't mentioned at all by David or Michael, which I think is a really interesting to see what happens, is the really big difference post-Brexit is the change in environmental oversight and enforcement. The European Commission used to take a lot of infraction proceedings in the areas of environment. It's about the biggest topic that used to have infraction proceedings on, including against the UK. The enforcement regime now has changed dramatically, and in place of the combination of the European Commission and the European Court of Justice, we've substituted the new Office of Environment Protection for England and I think still Northern Ireland, pending different legislation, different bodies in Scotland and potentially Wales. But I think it'd be very interesting to see. The government promised that this would be a world-leading, it's one of its favourite phrases, world-leading environmental enforcement body, and promptly made it significantly weaker in many ways in the Climate Change Committee. So it didn't really live up to its world-beating language. It'd be very interesting if the future government decided to strengthen the OEP's powers. So I think that's a sort of really interesting area to watch how that develops. As both David and Michael said, that what we term divergence in two things: passive and active divergence. Active divergence where you choose to do something different, passive divergence where you don't just keep up with EU law. But I think you're right to highlight that there'll be a lot of passive divergence simply because even if we wanted to, we've lost the very convenient, easy way we used to legislate to transpose EU directives. So you'd have to take new legislation. So even with the best will of the world, it would be incredibly difficult for the UK government, certainly under its current powers, to keep track with EU legislation. But Jacob Rees-Mogg made absolutely clear to the European Scrutiny Committee a few weeks back that he thought we actually shouldn't be interested in what the EU was doing. We had no interest in it. They're them, we're us. And why would we bother to track? Because, then he went on to say how interested he was in pharmaceutical regulation in India, which you could argue was a bit contradictory, because why is he interested in that? Because of the potential trade implications. But I think the UK government is in a very different mindset at the moment, certainly in the Brexit opportunities team that Rees-Mogg heads up, that it isn't looking to the EU as a benchmark anymore.
Thanks, Jill. That's some really interesting perspectives there. I just want to turn now to Northern Ireland and hear a perspective from you, Jane, what your thoughts are.
Yeah, morning all, thank you. Yeah, I think as David said, we're in a very unique circumstance. I think the problem is that sometimes that is sort of used to I suppose brush over some of the nuances and the complexities of Northern Ireland as they sort of they're stereotyped into one area, right? So it's difficult, it's complicated, so let's sort of not deal with it. And we're seeing that where questions almost can't be answered as to where does Northern Ireland sit. What does this new position of Northern Ireland in the protocol and within the UK and sort of larger, where does it put us? And we're seeing that Jill mentioned the common frameworks process. Frequently there's a caveat of this part of the common framework does not apply to Northern Ireland because of the protocol, etc., etc. So we're seeing Northern Ireland being caveated. That also aligned with the sort of the socio-political complexities of the protocol and the current situation in Northern Ireland means that Northern Ireland sits as this possible problematic loophole in a way that whether we, there's the active and the passive, or the by default, etc. We have political instability, meaning we don't have a functioning executive or an assembly. Laws and legislation and policy can't be produced, and therefore we risk sort of falling behind everything because decisions simply can't be made. Add on to that the additional burden on the civil service of having to be experts in multiple areas of law that perhaps they've never dealt with. We're facing this opportunity, or this problematic sort of perfect storm where Northern Ireland become a loophole of lower standards, whether it's by intention because people don't want to deal with Northern Ireland because it is too complex, or whether it's because there is no functioning assembly, executive, etc. So I think there's that sort of issue around the unique circumstance of Northern Ireland sometimes it causes more of an issue because people don't want to talk about it. I think added on to that, there's the fact that Northern Ireland for divergence is a shifting baseline. Now, obviously, there's the Scottish, Continuity Act with the keeping pace bar, which means divergence again is different there. But for Northern Ireland, we have a sort of a two shifting baselines. We've got the retained EU law, UK law, and then the protocol laws. And I suppose having that shifting baseline means that not only do we have to look in Northern Ireland to what the intra-UK, I suppose, divergence, but also there's a big concern of divergence on the island of Ireland. We are ultimately a single biogeographic unit, and we're seeing, powers already being granted to the Department for Agriculture, Environment and Rural Affairs to change water quality standards and monitoring. And that in itself is a technical, requirement, not being in the EU anymore. However, when you take it across the fact that we have shared water bodies on the island of Ireland, the potential for divergence becomes a real, on the ground threat. So sometimes sort of divergence is seen as this, theoretical, but that's a very real sort of, on the ground effect that we're going to see. And I suppose the final sort of thread I wanted to say or to bring up is, the discussion here is a lot on the big significant divergence, the big moments that are very easily seen or perhaps easily noted. But there's also that sort of death by 1,000 cuts where there's subtle divergence, little bits that underpin and undermine, whether it's the process of SIs being put forward, eroding trust with the devolved administrations, removing stakeholder engagement, removing expert input into these processes. And it's perhaps those little subtleties that actually will make a bigger impact in the longer term, because you have a civil service that are maybe not overwhelmed, but they're trying to get a hold of a massive new process and a new sort of way of working, and having that sort of hidden divergence or the subtle divergence actually undermining that, we could end up being in a much worse place rather than the sort of the big, statements by government about how they're going to go further or better or beyond, but actually they're not. So I suppose there's those two bits about just that subtlety of Northern Ireland almost being seen to be too complex and people don't want to touch it, and then that sort of that hidden divergence.
Thanks, Jane. And finally, Peter, I mean, what are your thoughts about the opportunities and threats of divergence that you're seeing?
I think, I'm a reporter, not an environmental expert, and I'd agree with Colin that what you see is a mess, and you often see a mass of contradictions. So, for example, they have moved to protect fish stocks on the Dogger Bank, which was welcome, but they only did it under legal pressure from NGOs. But 65% of fish stocks are still being overfished in order to compensate for where we ended up in the fish settlement on Brexit. Similarly, with the substances of very high concern, when the government put out its paper on that question, it highlighted the fact that it had put 4 of the substances of very high concern on the UK list, but it neglected to say that it had failed to put 6 of those substances on the list of very high concern. That's not a transparent way to do business. If it was super confident in its post-Brexit regulatory environment, which is still being built, it would say, well, we're not putting 6 on the substance of very high concern list, but for whatever reason, because we're going to take a non-precautionary approach and we're not going to follow the EU's toughened reach 2.0. But they didn't do that, and so that's where you start to see this constant divergence between, as Jill says, this nominal political top-level commitment to divergence as a sort of matter of principle, and Jacob Rees-Mogg laughably saying we don't care what the EU's doing. Well, I can tell you industry cares what the EU's doing. The car industry, the chemicals industry cares what the EU's doing. And you know, the inertia that's caused by gravity and by, frankly, confusion and a lack of resources. The NAO report that you referred to is very good on this. There isn't a clear line of sight between top-level political desire for divergence and the constant resistance that comes, A, from the reality of trade gravity, and B, from industry. And so I think it is a genuinely very messy and confused picture, where ideology constantly comes into contact with reality. It was really interesting. I mean, I reported on this, but I was genuinely really interested to see the level of pushback on the consultation on revamping the Habitats Directive that DEFRA has just done. Not just from NGOs, not just from the RSPB and Countryside Link, but also from port users and habitat directors. And it's very often forgotten that when you rip up regulation, you need to replace it with something. And then that requires organizations and companies to relearn a new type of regulatory environment. And the worst of all worlds, which is end up with a dual regulatory environment, which none of them want. Again, you know, with chemicals and REACH, I detect a lot of nervousness among the green NGOs and green lobbies, and a certain satisfaction among the chemical industry that they've got this 2-year delay on how the UK REACH database is going to be populated and the level of data that's going to be required to do that. But again, you know, we don't have clarity still about how that compromise is going to be reached. So, you know, in summary, I suspect that there's an awful lot of hedging going on. There's a lot of top-level commitments to divergence, and indeed top-level commitments to maintaining standards. The Environmental Act of 2021 says that they can't go backwards. But when you get under the hood of that, that's ultimately a determination by the minister whether they're satisfied that whatever they're doing has not brought it backwards. You know, they get to mark their own homework. There's a lot of, you know, little doors being left open here, which is why I'm afraid we're going to need Jill's and Joelle Relland's divergence tracker to keep an eye on what they're actually doing, because across Whitehall there's always push and pull between DEFRA, between DIT, who obviously need to negotiate trade deals, and we haven't crossed the issue of negotiating US trade deals, and dealing with industry lobby pressures and environmental lobby pressures. And it is going to be messy and piecemeal and fascinating, but it's going to keep people like me very busy.
Thank you, Peter, and thank you to you all. I mean, it from what you're saying, I mean, it sounds like despite there being some opportunities that you can identify, actually there are a lot of risks identified and an awful lot of uncertainty around a lack of clarity about the direction of travel, which is why it's so important that we carry out this tracking and we try and understand exactly what's going on. I see there are already some questions, and in the interest of time, because we are very pressed for time this morning, I thought I would go straight to those. And the first one is do the panel have any views on how the tension between polar changes following a broadly EU or US model and UK global leadership is playing out? Is any of this divergence really new and UK specific, and are we really seeing a shift to more US style systems? And are there areas where the UK alone will find it particularly difficult to diverge by showing individual global leadership? I don't know if who would like to respond to that initially. Any takers? Jill, is that, or Peter?
Well, I know I would say, you know, preface, but the usual thing is it's a very murky picture. But I would say the door is being left open to a more US style approach, right? I think, you know, the precautionary principle, what you hear in Whitehall is that, you know, well, all these officials, they're all captured by 40 years of EU thinking and being told what to do by Brussels and by by Helsinki, by the chemical regulation bodies in Helsinki, and we need to shake them out of that. So I think there is an absolutely political top-level commitment, but by the same time, that has to work against. So you see these doors being left open to a less, for example, with a substance of very high concern, a more less precautionary principled approach. But it's interesting, I've sat in meetings with Brexit MPs in the House of Commons, having innovation lunches and dinners, banging the drum for, this new super innovative approach that they want to have, unshackled from, the dead hand of EU regulation. And I was once sat next to the CEO of a very large European chemicals company who just shook his head, who just said this is just nowhere close to where the reality of industry and businesses. So it may be that they are leaving the door open to, I definitely detect that, to a less EU-based approach, but it may be that it doesn't deliver quite the level of change that they anticipate.
So,
Jill, did you want to comment?
Kaylee,
Yes.
I mean, I agree with Peter that I think the new approach to precautionary principle in the DEFRA's environmental principles is quite interesting. And the government, I think, would say that it is reorientating towards what it sees as a more science-based approach, whereas it thinks that the EU has been anti-innovation and overly cautious. We'll see how that works out. But I think your exhibit A on that would be the legislation that's being introduced on precision technology, aka gene editing, which I think is very interesting. There's an interesting question there about whether the UK is going in a direction that then the EU may actually come along a bit later, because the UK should be able to, move more nimbly in some of these areas where it doesn't have to act at the level of 27. I think there's quite a big difference. I think what's very interesting about this government, for a Conservative government, is, and this is very different, I think, in some ways from where Theresa May's government ended up, is it really is quite indifferent to the concerns of business. Peter may disagree, but I think it really doesn't particularly care. But on a lot of environmental issues, in the Conservative manifesto in 2019, they pointed to the ability to diverge on environment, but to move above EU standards, not to diverge below. And indeed, the TCA incorporates non-regression clauses and things like that. So I think it's really interesting. And I think one of the problems from this government is that even before last night, it did not have very reliable majorities in Parliament. An awful lot of its deregulatory ambition, we saw this when they started to consult internally to have a discussion about potential changes to workers' rights, doesn't necessarily have majorities for these changes in Parliament. So it's constrained in a sense on the active divergence front, on where it can create parliamentary majorities, particularly given that sort of manifesto commitment to raise environmental standards, which mean it would also run into loads of problems potentially in the House of Lords.
Thanks, Jill. And we're getting quite a lot more questions in the Q&A, and perhaps I could bring in David and Michael to join the panel at this point, because I'm sure they have points that they would like to respond to as well in relation to their presentation. So if we can bring them in too. I mean, there's one question here in the Q&A, which is, what advice do you have for the Welsh Government as they consider their permanent arrangements for independent environmental governance? And how do you assure effective functioning of that in the face of divergence across the UK? What thoughts do people have on that?
Well, I think that in some sense, Wales has got the advantage of they can wait a couple of years. They are waiting a couple of years, which isn't necessarily itself a good thing, but they can see how the OEP and Environmental Standards Scotland work out, what actually seems to work, what doesn't. I think I would hope that in Wales they're able to produce something that's closer to the Scottish version, where there are significant powers for the watchdog to call government bodies to account. But I think that in areas like this, an awful lot depends on political will, or the political willingness of government to accept external objective criticism as something they should take seriously, as opposed to something they should just brush off. And I think that various governments around the UK at different times, they've not necessarily been particularly good at taking external criticism as something serious that they should respond to, rather than just something to brush off.
I can make just a quick point. I think my advice from a Northern Ireland perspective is don't sort of feel the need to follow. You know, for Northern Ireland, obviously we're in the Office for Environmental Protection, and we're in the Environment Act to a certain extent. Now that was caused by the fact that during that time we had no assembly, we had no executive, so we weren't going to have any post-EU governance, which is, you know, it's a fantastic framework that we're part of, and obviously we'll see how it grows and it develops. But I think the point of that I want to make is not just simply look at just the governance body or the enforcement body or whatever you want to call it. It's looking at that suite. You know, the discussion of environmental legal principles has been brought up, and some would call it interesting. I suppose from our perspective, we would call it concerning. You know, we're seeing an approach that is reducing the legal weight, the legal status, and the legal scope of these really important principles that have been such a key part of a number of decisions, whether within the courts or within government. And I suppose my point to the Welsh government would be ambitious across the suite of environmental governance, not just your enforcement body, but those principles, ensure that they're robustly established. You know, for Northern Ireland, we have this dual instance of principles within the protocol, principles within the Environment Act, and we're yet to see a policy statement, and we would very much hope that it would go above and beyond where I suppose DEFRA have left theirs. But yeah, it's that need to look beyond just a simple, you know, the enforcement body is one part of the puzzle of post-Brexit, you know, enforcement, regulation, governance, policy, whatever it is. So there's that need to sort of not be weighed down by just focusing on one aspect, and looking at ensuring that there's a robustness across the entirety of how government is going to function post-Brexit.
Thank you, Jane. David, did you want to come in on any of the points that have been raised so far?
Thanks, Kenny. If I'm allowed, just a couple of points. I was struck by the panelists all come out with a theme. This is quite messy. And I think this is one reason why we've been saying in our paper, we need transparency, clarity, and a bit more explicit statement about real goals. Okay, we're always going to have, you know, political posturing and some contradictions, but we could do with something which is a bit more strategic. We're definitely heading into a bigger and bigger mess. And I take Peter's point, we get the same message as you do from industry. They don't want divergence in a number of areas quite clearly, but there's no clarity about, you know, how far that really is a concern for the UK government or it isn't. And it would be quite good to know. And an aspect that's also come out of this discussion is the importance of institutions. I think all the panelists have said, well, have we got the capacity to do the things that now need to be done? Now we haven't got the European institutions to do it for us. And there really hasn't been a debate in the UK about how we build that capacity to actually run our own system in an effective way. And so one advice I think to Wales must be, well, do think about that institutional problem and how far you can build the right institutions or work with others where that is more cost effective. I did mention briefly, Jill, the whole sort of OEP enforcement point, but skipped over it. It's a fair comment. One difference post Brexit is the OEP has got to only focus really on England and Northern Ireland. So you could say they could scrutinise what goes on a lot more thoroughly than the Commission did. The Commission would take out, 3 or 4 cases against the UK a year maximum. Now we've got a body which has actually got the competence to really look at the whole legal system, the process. So potentially they have a bigger role in sorting out the mess in terms of clarification, transparency, challenging in a way that the Commission couldn't have done before. So I think thinking about the institutional angle is quite an important one as we go forward. It's perhaps beyond divergence, but quite an integral part of it.
And perhaps linked to that, there are a couple of questions in the chat about the proposals to reduce the size of the civil service and what implications that is going to have on divergence. Is that going to lead to reduced ambition? You know, how can that be? You know, how can we make sure that we have sufficient resources to actually deal with the issues that we're confronting? I don't know, Jill, whether you that seems appropriate
I think
for you.
Since I also work at the Institute for Government, I think I probably ought to come in on that one. So the government wants to take the size of the civil service back to its pre-Brexit level in 2016, which reflected 6 years of cuts from 2019 to 2009 to 2016. But it doesn't recognise in that Brexit has actually meant you need more civil servants to do a lot of the things that have been repatriated from Brussels, and you ought to actually be rescoping the civil service for that. I think one of the real risks is one, that there's a sort of bit of a lack of capacity in policy development, because these are areas where the UK has been a negotiator rather than a policy lead for many years. And we saw that actually during the process of the Brexit negotiations, when departments realized they actually didn't have this sort of knowledge and had to pull it in from some of their arm's length bodies. So DEFRA took in a lot of people from Natural England and the environment agencies. That's where there was more knowledge than there was in the core department. But I think, and Peter and David both mentioned the NAO report, and Michael on enforcement. And I think the real problem is that enforcement bodies are being squeezed from multiple ends. One, they may be asked to make cuts. Two, they're running high levels of vacancies. They depended actually bizarrely on two things from the EU. Quite a lot of EU qualified staff used to work in them and don't. Quite a lot of them have gone home. And the second is that they actually have more tasks, but also potentially less income, because some of those regulators used to also undertake contract work for EU bodies, and that income isn't being made good, I think. So I think actually one of the things I would look at is the gap between ambition and ability to enforce that ambition, because you can have fantastically bold legislation, but if everybody knows there's virtually no penalty for ignoring it, then it's a pretty weak regime. So it's important to do the whole end-to-end process. And I think the lack of civil service, the reduction in civil service numbers will affect that whole end-to-end process of policy making into enforcement.
Thank you. Did anyone else want to come in on that? Colin, yes.
Can I just say it also affects other bodies, particularly local authorities, and capacity and expertise, the biodiversity net gain, the nature recovery stuff. A lot of this is looking at environmental outcomes, trying to work towards the future and so on. But if we don't know, if we don't have the expertise, the capacity to assess current baselines, we don't have the capacity, expertise to assess whether plans are actually realistic, robust, and so on, and we don't have the capacity to make sure they're going to be enforced in 20 years' time, that what is a very exciting, bold, interesting idea just collapses because it will never work in practice.
Yeah, and a very quick point to add on to it, and it is that it's the sort of the funneling of pressure and resources, is that then civil service are also looking outside to find answers, whether it's from institute like the Institute of Environmental Policy, or NGOs. We're frequently being asked questions about, well, what's your position on, does this affect does the protocol affect this aspect of environmental law? And we were asked that in relation to due diligence. And it's not for us to answer, and we don't have the resources, but there's that sort of top-down pressure of we need to find someone else to give us the answer. But everyone is already trying to deal with whatever divergence is and whatever Brexit is, and then added on to these additional questions coming from government asking, we need help, because again, no one really understands sort of where either the baseline is or where we're going to. So there's just that additional sort of it's a sort of a let's ask someone else issue. So we're definitely saying that.
Yeah, it's a fine line between stakeholder engagement and getting the stakeholders to do work the government should be doing, which very at times seems to be verging towards that.
Thank you. There's another question that's come in, which I think is probably one for perhaps Colin and Jane specifically, which is about how the push in England for divergence is actually affecting divergence within the devolved administrations, and the example given in the question is about on biodiversity and the downgrading of Natura sites. But you know, this issue obviously will affect cross-border and offshore proposals. So what are your thoughts on that? Do you see that push to divergence in England having having cross-border impact into other UK nations?
It certainly will have an impact. You're definitely not seeing the same push to deregulation in Scotland. Even looking south of the border, it's still very hard to work out what's actually happening, because you have the UK government talking in two diametrically opposite ways in terms of its nature recovery ambition and deregulation. And things like the Levelling Up bill have major powers to change things, but absolutely no indication of which direction they're going to change. And also, to complicate things further, they tend to muck up the devolution settlement, because again, the Levelling Up bill says that the UK ministers can make rules on replacements for environmental impact assessment that will apply in Scotland and other parts of the UK after consultation, but without consent of the Scottish ministers. But then the particular details that are mentioned are ones that apply to England only. So it's really hard to work out what the UK government is doing for England, how far it sees that as applying to the rest of the UK, how the different fragmented powers to impose that on the rest of the UK, bearing in mind also the Northern Ireland Protocol, Trade and Cooperation Agreement, and the Single Market Act. It's just totally unclear. And I think my impression is that at present, not an awful lot's happening in Scotland, partly because they're still recovering from COVID and so on, and partly we haven't quite got to the real crunch yet, where big decisions have to be taken.
Yeah, I would agree. It's that lack of certainty as to what actually is being sort of acted on, or what they actually want. But I think it comes down to ultimately there's no commitment to non-regression, and these are the first examples, I suppose, of regression that we're seeing, and they are incredibly worrying. But from a Northern Ireland perspective, what it is it's that first country taking the first step in the wrong direction, right? So it starts as sort of perhaps a tidal wave of, right, well, we'll follow that. And in Northern Ireland, again, it's that subtle sort of nuances of the way our executive is formed. So if we're seeing that happening in England, some political parties will want parity with England, and they will want to follow suit, which of course would be a really big problem, especially given the cross-border sites. We have so many of our former Natura sites are cross-border, but certain parties will want parity with England and certain parties will go in the complete opposite direction. So as an environmental sector, we're sitting going, we could have polar opposites, or we could have absolutely nothing. At the moment, we have no change. And, the DERA website says at the moment, there are no changes to, Birds and Habitats Directive, but that could change and it could go one or the other way, possibly not for legitimate reasons. It could just simply be a political play, but also it could be that case of there's an opportunity for us to say, well, hold on, just because they're doing it doesn't mean you have to do it. That's, a different country. It's their capacity to do it. But definitely, I think there's that point of it's uncertain as to what's being achieved or what they want to achieve. And then we're sitting in this world where we could have parity with England or we could have, the sort of, I suppose, the status quo, because we don't have a functioning executive.
Thank you, Jane. And I'm conscious of time, and we are coming to I'm going to have to finish the Q and the panel discussion, I think. But there are a lot more questions in the chat. I mean, all sorts of questions from well, what does that divergence between the UK nations then mean for compliance with international agreements? Do we have sufficient baseline information against which to measure divergence, and so on and so forth? So just rest assured, we are recording and taking note of all the questions you have, and those will inform future work that we do. So many thanks for your questions, and of course many thanks to the panelists for such insightful contributions. And I'm sorry to have to shut down such an interesting discussion so soon. So apologies for that. but before we close, and before I say a little bit about our next steps, the chair of our UK IEP UK's board, Malini Mehra, has managed to join the event. In fact, she has been there from the beginning of the presentations in the end. So I just wanted to pass the floor to her, perhaps, to say a few words before I close.
Thank you very much, Kaylee, and thank you very much for the excellent chairing. As you said, my apologies for not being able to join at the very beginning, but the conversation in the past 1 hour has just vindicated us. I think that when we restarted the project of IEP's presence in the UK, we were clear that we wanted to focus on what we were seeing, these tensions appear, both within the EU and the UK, but importantly also within the country. And the conversation that we've had in the last 1 hour has just reinforced the fact that we have proceeded on a quite dangerous, potentially, and disorderly transition. The words messiness, chaotic, lacking in clarity, a mismatch between the rhetoric and the reality, a mismatch between ambition and capacity. They make me sit here and feel quite concerned. So I'm absolutely thrilled that we are in such excellent company, that we have such fantastic partners in academia, in NGOs, now also in the media. And I would love for this conversation to be extended to parliamentarians, to local authorities, to industry, all of those who have an opinion, but have been too downstream from the decision making. So thank you very much to everybody. I thank you on behalf of the board of IEP UK and look forward to our next conversation. And with that, thank you very much, and back to you, Kaylee.
Thank you, Malini. So yeah, just remains for me to say a few words of thanks, but also a few words perhaps on the next steps of what we're doing on this topic. I'm really pleased to see how much interest and engagement there has been on the topic, and we could have filled a much longer event. And I think that fills us with confidence that we are working on the right sort of topics, and this is something that is really worthy of further research and further action. So with that in mind, over the next few months, we're going to be delving more deeply into a range of thematic topics. We're going to be convening a number of more meetings of our expert group over the coming 6 months, our hub, if you like. We're also going to be having more seminars and webinars on a variety of thematic topics. So I hope you'll be interested in joining us on those. And we'll be publishing a number of case studies onto our website as well. And of course, we're going to continue with the legislative tracking that Michael explained. And the aim is ultimately to publish this, or at least a version of this, on our website in due course. So lots of activities to take place over the summer and the autumn, and I very much hope that you'll join us on that journey. So with that in mind, I think it just leaves me to thank our speakers and panelists once again for their contributions, and to thank all of you for joining and for such a stimulating discussions and stimulating webinar. So have a good rest of the day, and we will be in touch. Thank you very much.